As part of our continued research and study about philosophical idealism and the problem of justice, let's start talking about German transcendental idealism. The comparatively brief period during which Germany produced an abundance of great philosophers, poets, and musicians and scholars has also profoundly influenced the further development of legal thought. The three great philosophers, Kant, Fichte, and Hegel, of whose legal philosophy an account is to be given, do not merely exhaust the intellectual fecundity of the period, but they are the outstanding figures, and each of them has devoted a considerable part of his philosophy to the law. Widely as Kant, Fichte, and Hegel differ in their systems and conclusions from each other, they share some fundamental ideas. They all deduce their legal philosophy from certain fundamental principles, which they discovered through an inquiry into the human mind. In studying the human mind, they start from one fundamental Aristotelian principle, that man is a rational, free-willing being, distinct from nature. Man as an animal is indeed part of nature, and as such, he is subject to the physical law of nature. But being endowed with reason, he is at the same time distinct from nature and capable of dominating it. Point of departure provide a substantial community of outlook among the three philosophers. Their conclusion in the field of legal philosophy are nevertheless widely different. Let's get to know more about the three great philosophers. Now let's start with Kant. Kant, embodying and developing in a comprehensive and profound system the results of centuries of philosophical thought, gave modern thinking a new basis which no subsequent philosophy could ignore. The Copernican turn which he gave to philosophy was to replace the psychological and empirical method by the critical method, by an attempt to base the rational character of life and world not on the observation of facts and matter, but in human consciousness itself. This Kant did by a systematic inquiry into the functions of human reason. His main work consists of three principal parts, in accordance with the three functions of human consciousness: thinking, volition, and feeling. The first part, the critic of pure reason, deals with perception. The second, the critic of practical reason, deals with morality, while the third, the critic of the power of judgment, deals with aesthetics. Of these, only the first two need concern us. For an understanding of Kant's own legal philosophy, we could be content with the second. Kant himself did not apply his discoveries on the theoretical possibilities of human knowledge to his principle of morality. This includes his own legal philosophy. For him, the realms of perception and volition were derived from entirely different principles. The neo-Kantian philosophers, of whose theories an account will be given later, have based their legal theories on Kant's theory on the knowledge, not on his theory of law. Thus, a brief introduction to Kant's theory of knowledge is indispensable. Kant, in his Critic of Pure Reason, set himself the task of analyzing the world as it appears to human consciousness. Absolute reality is such, Kant, like Plato, holds to be unknowable to men. Kant draws a fundamental distinction between form and matter. The impressions of our senses are the matter of human experience, which is brought into order and shaped by the human mind. Emotions become perception through the forms of space and time. Perceptions becomes experience through the categories of understanding, such as substance and causality, quality and quantity, etc. The judgment of experience are linked with each other by general principles or ideas. This is all about Kant. Now let's go to Fichte. The comparison between Kant's and Fichte's legal philosophies demonstrates how, from a common theoretical standpoint, it is possible to reach the most divergent conclusions where political ideals differ. Fichte legal philosophy is deduced, like Kant's, from the self-consciousness of the reasonable being. No reasonable being can think himself without ascribing free activity to himself. But this he cannot do without ascribing it equally to others. Freedom is of necessity mutual. The sphere of legal relations is the part of mutual personal relations which regulates the recognition and definition of the respective spheres of liberty on the basis of free individuality. It only refers to actions, not to motives. On the relation of law and morality, Fichte develops Kant's doctrine. Whereas there is a moral duty to respect the liberty of others, absolutely a legal duty to do is dependent on reciprocity. Fichte did not, however, demand a written constitution to fix the fundamental rights. Fichte's social contract is divided into property contract and a protection contract. Through property, one becomes a citizen, but the correlative of this is that everyone must have property, since no one must be excluded from the legal community. The relation between individual and state is defined in three principles. Through fulfillment of civic duties, the individual becomes a member of the state. 2. The law limits and assures the right of the individual. And 3rd, outside the sphere of civic duties, the individual is free and only responsible to himself. He is man, not a citizen. The right to punish is part of the social contract and based on retaliation. But the aim of reforming the criminal modifies retaliation. Criminal law embodies and ensures the protection of rights guaranteed by direct state. Now let's go to Hegel. Hegel's philosophy is the most comprehensive and ambitious attempt ever undertaken to give a complete theoretical explanation of the universe. Hegel is not content to analyze knowledge or will or natural sciences or logic or history of law. All are welded by Hegel into a gigantic unity in which not only the whole universe is contained, but in which all antinomies or conflicts, dualism, or the ideas all real forces are eliminated. The idea, which is reason and spirit, contains them all. Hegel's system is monistic one. The idea unfolds the simple to the complex by means of the dialectical process. Thus, there can be no dualism of any kind, for any phase of reality is based on reason. What is reasonable is real, and what is real is reasonable. The whole task of philosophy is to Hegel the vindication of that conviction, and consequently, he emphatically rejects any antinomy between idea and experience or reason and reality. What matters is to perceive in the appearance of the temporal and transitory the substance which is immanent, and the internal which is actual. For the reasonable, which is synonymous with the idea in that it assumes external existence in its actuality, appears in an infinite variety of forms, phenomena, and surrounds its kernel with a shell in which consciousness dwells first, and which the notion then penetrates to find its pulse, to feel in its manifold appearance. The absolute spirit contains and comprises all previous stages of development, and therefore is at the beginning of all things as well as at the end.
Let's move on. Neo-Kantianism. So what is Neo-Kantianism? Neo-Kantianism refers broadly to revive type of philosophy along the lines of that laid down by Kant in the 18th century. Also, more specifically by Spengler's criticism of the Kantian philosophy. This school of thought was of importance in devising a division of philosophy that has had a durable influence well beyond in Germany. The term neo-Kantianism can also be used as a general term to designate anyone who adopts Kantianism view in a partial limited way.
Stamler defines law in his heavy and attractive style as number 1, binding, 2, sovereign, and 3, inviolable volition. Law is first of all volition, because law is a mode of ordering human acts according to the relation of means and purposes. Combining volition signifies volition of men in their mutual relation. Sovereignty distinguishes law from arbitrary volition of an individual, but must not be understood in the sense of political sovereignty of one will over another. The permanency of the tie created by law is indicated by its inviolability. All these elements have formal, not material significance. In plainer language, this definition is not far from the current definition of the analytical school. It contains the elements of mutuality, compulsion, and sovereignty. Stamler naturally rejects such conception as the spirit of the people. Nor does he admit that the state determines the law. The state is nothing but a particular type of legal order. Stamler can therefore conceive the logical possibility of word law coordinating and combining all particular and limited legal order. The idea of law is Stamler's counterpart to Kant's practical reason, the realm of purposes realized by volition. But while Kant's critical knowledge or pure reason of the things perceived by the senses is opposed to purposes set by belief and volition or practical reason. For Stamler, the critical knowledge of law is not the knowledge of a physical phenomenon. It is the analysis of purposes to which the idea of law gives a unifying direction. The purpose of Stamler's idea of just law is to help in building up a fundamental conception of life, as put by Stamler in the concluding chapter of his theory of justice. First, just law is the highest universal point in every study of the social life of men. Second, it is the only thing that makes it possible to conceive by means of an absolutely valid method of social existence as unitary whole. Third, it shows the way to union with all the others endeavors of a fundamental character which aim likewise at right consciousness. And Stamler is not content with formulating these principles. A large section of his theory of justice is devoted to an attempt to apply these maxims, formal as they are meant to be, to the solution of actual problems, most of them taken from the German civil law. Stamler examines the principles of just law under 5 headings. 1. The right exercise of legal relations. 2. Limits of freedom of contract. 3. Duties of just law. 4. Determination of a just transaction. 5th. Justified determination of legal relations. Stamler's criticism. The importance of Stamler's theory can be gauged from the flood of controversy which it has provoked. Before 1914, in a world overwhelmed by the mass of new discoveries, new material for observation and classification, Stamler expressed the urge for the scientific clarity, unity on one hand, and a new idealism on the other. This new scientific idealism was both more arrogant and more diffident than that the natural ideologies of freed centuries. Arrogant in that it thought everything knowable, diffident in that the 19th century idealism was too skeptical to establish absolute ideals. Nor did it possess the unity of moral values backed by one of predominant authority, such as the medieval church, which absolute ideals presupposes. But no English lawyer would claim that this is more than one of several possible solutions. Stamler's solution is based on the following assumptions. First, recognition of private property however unequal in value and amount, subject to certain limitation in the use of that property. Second, equivalence of all uses of property, regardless of their economic and social importance.
Modern value philosophies and the law. Let's start about relativism. Scientific relativism seeks to do justice to both these aspects of human nature and to see them in their proper perspective. Its cardinal point was developed by Max Weber in a celebrated essay written in 1917 in the midst of the hazard of war, which tainted thinkers and scientists in all belligerent countries. With supreme detachment from the blindness of these passions and a deep convictions of the true task of science, Weber developed the thesis that no value in the field of sociological and economic sciences could be scientifically proved. He showed that such allegedly scientific demonstrations as tendencies of progress, right economic behavior, and similar formulas covered ethical evaluations. The true task of social science was the intelligent explanation of social phenomena up to the point of ultimate valuations, between which is not the task of science to choose. From this relativism, on the one hand, in the studies of some neo-Kantian philosophers, Gustav Radbruch has developed illegal philosophy. It shares with Kelsen's pure theory of law the emphasis on the necessity of distinguishing between valuation and science and law. But to Radbruch, who follows the philosophy of lust, the essence of law, a formal order of norms. All culture aims the realization of values, not merely at perception. It is thus practical, not pure reason. Law must thus be conceived as a totality of facts and relations, whose purpose it is to realize justice. It is the task of legal science to analyze the law as a factual unity of cultural values. It is the task of legal philosophy to analyze the law and its specific valuations. Radbruch's legal philosophy therefore sees its proper task as starting with the pure theory concerned with legal science only stops. Its task is threefold. To give more emphasis in this concern, let us view the following slide. This legal relativism is therefore concerned with the ultimate meaning of legal systems, but does not see its task in suggesting a choice between opposite values. This choice is a matter for personal decisions, a matter not of science but of conscience. Relativism does not evade political decisions, but does not wish to give them a scientific look. Legal science and philosophy can show these antinomies but not indicate a choice between them. Radbruch further concludes the relativism because it refuses to decide between conflicting political ideals, must concede to every political opinion which succeeds in securing the majority in the state the right to assume political responsibility. In other words, it shares democracy's belief in political tolerance. The law must be certain. The demands of justice and of passivity are invariable parts of the idea of law. They stand above conflicts of political opinion. Utility provides the element of relativity. But not only utility itself is relative. The relation between the three components of the idea of law is relative too. How far utility should prevail over justice, or security over utility, is a matter to be decided by its political systems. To give more emphasis about this concern, let us again view the succeeding slides. Again, positivity of law often means certainty at the expense of justice or the consideration of the individual case. Even patently unjust decisions continue to be recognized in the interest of legal stability. In history, the authoritarian police state tends to make utility the dominant element. The natural law period emphasizes the element of justice and tries to give it substance. Legal positivism considers nothing but certainty of the law and neglects both justice and utility. But the free judicial interpretation advocated by modern theorists emphasizes again utility rather than certainty. Radbruch also considers the possible contents which may be given to utility as determining the end of the law. He finds that there are three possible objects of valuation in life: individual personalities, collective personalities, and works. Accordingly, social and therefore legal systems can emphasize either individualism, collectivism, or what Radbruch styles transpersonalism. The first values the individual and his integrity higher than the needs of either the community or any cultural, scientific, technical, or other government or of civilization. This is typified by the American Constitution. The second sees that individual life as well as achievements of civilization culminate in community life. This is typified by Hegel's philosophy. The third would consider an Egyptian pyramid or a modern road through fever-stricken country as more important than the thousands of lives sacrificed for this work. To give more emphasis about this concern, again, let us view the succeeding slide. Talking about phenomenology, existentialism, and contemporary legal philosophy. One of the most important aspects of neo-Kantian thinking has been the attempt to bridge the gap between action and knowledge, between intuition and understanding. One of the most significant applications of this new approach to the theory of knowledge has been the movement that is generally and loosely described as phenomenology from the basic work of Edmund Husserl. While this general description covers a great variety of trends in modern philosophy, the common theme of the many variations is the postulate that the Kantian antinomy between the individual and the world, between the categories of thinking and the object with which it apprehends, can be overcome by the apprehension of the immediately given in the world of consciousness by the concrete and underivative experience of the phenomena, as they confront man in their total or undivided fullness and immediacy. To give more emphasis to this concern, let us view the succeeding slide. Concerning existentialism, perhaps the most widely discussed philosophical movement in the post-war world, does not by itself contribute much to the philosophy of law, since it is essentially concerned with the existence, the struggle to become of the individual in a world into which he is thrown. Heidegger, Jaspers, and Sartre, the main exponents of this philosophy, have all, though in different ways, been concerned with the ways in which the individual can overcome his loneliness by realizing himself in a hostile world. But there are attempts, especially in the philosophy of Jasper, to see law and the evolution of the legal order not merely as an external compulsion imposed by a hostile world upon the individual, but as part of his self-realization. Just as nature cannot be denied without man destroying himself, so man cannot reject society, profession, state, marriage, and family without being blown to the winds and he can find himself only if he enters into it. Since existence can only realize itself in communication, the law is considered at least the protective function insofar as it gives man a minimum of social security and protects the individual from the fear of the invasion of the uncertain. In non-essentialist terminology, this apparently means that the individual, however much he may struggle with the realization of his self, can do so only within the framework of a social order and minimum rules for the living together of numerous individuals, under conditions that permit each of its members to realize himself without the fear of chaos. An important attempt to develop a legal philosophy of existentialism is that of Mayhofer, who seeks to overcome the isolationist individualism of existentialist philosophy by conceiving man as a being not by for himself but as subject-object mundi homi. His existence is Sartre's words, the conquest of his self. With respect to modern Latin American legal philosophies, the Spanish-Mexican jurist Luis Recasens has been principally concerned with an attempt to reconcile the objectivity of judicial values on the basis of Schiller's and Hartmann theories, the historicity of judicial or juridical ideals. He distinguishes five sources of historicity. To give more emphasis about the five sources of historicity, let us view this slide.